The appellants may be seated during the reading of the judgment. This is a judgment in an appeal matter against the refusal of bail, heard in the Magistrates Court in Windhoek. I will now proceed to read this court's judgment into the record. The judgment was prepared by myself, with my sister Usiku concurring. Introduction. The aggrieved appellants, having been unsuccessful in their application for bail decided in the Windhoek Magistrates Court, lodged an appeal against the Court Akwo's ruling delivered on 24 May 2022. The appeal is founded on grounds enumerated in the respective notices of appeal filed by the appellants, contending that the presiding magistrate erred in law and/or the facts in several respects when concluding that the appellants are not suitable to be admitted to bail. The first appellant is represented by Mr. Mata and the second appellant by Mr. Amumu, same counsel who appeared for the applicants in the bail application. Mr. Lilungwe appears for the respondent. Both appellants are charged with one count of contravening Section 18, subsection 2B of the Riotous Assemblies Act, 17 of 1956, and a further count of public violence. In addition, first appellant faces a third count of assault by threat. Both appellants, during their testimonies in the bail application, intimated that they would plead not guilty to the said charges at the ensuing trial. The state's grounds of opposition. The formal bail application lodged by the appellants was opposed by the respondent on the following grounds. A. The charges brought against the appellants are serious. B. It would not be in the public interest to release them on bail. C. It would neither be in the interest of justice to grant bail. D. The appellants, if released on bail, might commit similar offences. And E. The state has a strong case against the appellants. Each appellant testified in support of his bail application, while the respondent, in opposition, led the evidence of the investigating officer, Warrant Officer Nakanyala. It is common cause that the first appellant is currently out on bail in another case pending before the High Court in respect of charges that relate to fraud, tax evasion, money laundering, and further charges in contravention of the provisions of the Prevention of Organised Crime Act 29 of 2004. First appellant has also been convicted of culpable homicide, against which he has a pending appeal. As for the second appellant, he is equally out on bail in yet another pending trial on charges under the Squatters' Proclamation, AG 21 of 1985. The law relating to bail appeals. The provisions of Section 65(4) of the Criminal Procedure Act 51 of 1977, hereinafter referred to as the CPA, make plain that the Court of Appeal may not set aside the decision against which the appeal is brought unless satisfied that the decision is wrong. I endorse the interpretation given to this section in S versus Timotheus and cases cited therein. Thus, there is no need to paraphrase well-established legal principles. Suffice it to say that, irrespective as to whether the Court of Appeal may have a different view from that of the court hearing the application, quote, it should not substitute its own view for that of the magistrate, because that would be an unfair interference with the magistrate's exercise of his discretion, unquote. C.S. versus Barber. The approach of the appellate court is to determine whether the magistrate who exercised his or her discretion to grant or refuse bail exercised that discretion wrongly. This court in Barbie versus S added thereto the following at paragraph 6, and I quote, "It is further tried that not every misdirection will arouse this court's interference. A misdirection or error must be material and not simply criticisms immaterial to factual findings of the court a quo. The appellant further bears the onus to prove on a preponderance of probability that it is in the interest of justice that he should be granted bail. To this end, an applicant must place before the court reliable and credible evidence in discharging this onus," unquote. Next, I turn to the grounds of appeal. The appellants in their notices of appeal in total enumerated 16 grounds of appeal. Of these, some are either repetitious, whilst others simply amount to conclusions reached by the author and clearly do not satisfy the requirements of being clear and specific. See S versus Kakulolo. As regards the first appellant, his grounds 5 and 6 fall in this category and need not be considered for purposes of the appeal. Jointly, the appellants essentially attack the court a quo's refusal of bail on the following grounds. 1. The magistrate's assertion that he was not privy to those circumstances that led to the release of the 6 co-accused on warning. 2. That the court a quo misdirected itself in its understanding of the meaning of, quote, re-offending, unquote, when finding that both appellants were out on bail on other pending matters with bail conditions when allegedly committing another offense. Furthermore, the court's finding that there are no appropriate bail conditions that would sufficiently allay the state's fear of the appellant's re-offending. 3. The strength of the state case, as testified to by the investigating officer, was misplaced in the absence of any risk of absconding. Furthermore, it is contended that such testimony amounted to inadmissible hearsay evidence. Also, that the court gave undue weight to the content of evidence about video recordings and statements which were never placed before the court. 4. That the court's reliance on Section 61 of the Criminal Procedure Act 51 of 1977 was wrong, where the court did not attend to an inquiry as contemplated by the section. Moreover, where the investigating officer was unable to say how the interest of justice would be compromised by the granting of bail. 5. In the absence of evidence concerning the risk of possible harm or danger to the public caused by the appellants, the court erred when refusing bail on the basis of it not being in the interest of the public to grant bail. I now turn to deal with the respective grounds of appeal. The magistrate's assertion that he was not privy to the circumstances that led to the release of the appellant's co-accused on warning. It is common cause that 6 of the appellant's co-accused, charged with the same offences, except for one additional count of assault by threat only against first appellant, were released on warning by the police on the same day of their arrest. Other than Warrant Officer Nakanyala's testimony that this decision was taken by senior police officers, he was unable to advance any reasons why the appellants were not treated in the same manner. This prompted the magistrate's remark in the judgment that he was not privy to the circumstances on which that decision was based, and that the police might have had grounds or reasons to do so. The respondent submitted that the decision to oppose bail or not lies with the state and the law enforcing agencies, whereas the court exercises its discretion after hearing evidence to grant bail or not. Also, that the circumstances and involvement of each accused may differ from one person to the next in a particular case, which could lead to some being released on warning whilst others have to lodge a formal bail application. It is against this background that counsel for the appellant submitted that the court a quo failed in its duty to conduct a proper inquiry as envisaged in the case of Charlotte Helena Botha versus the state, where it was held that where the state for or the defense, quote, fails to put questions or relevant points or to raise relevant legal or factual issue, the presiding judge or magistrate cannot shield behind this omission, but must make use of his or her powers as administrators of justice to ensure that he or she is placed in the position to do justice between man and man, unquote. It seems to me that the release of 6 co-accused facing the same charges as the appellants on warning, and not the appellants, was a material factor which required further scrutiny by the court during the bail application. For all means and purposes, their co-accused were in the same boat and ought to have been treated the same, except where compelling circumstances existed which required a different approach. At the time of the bail hearing, there was no evidence that remotely explained the differentiation made by the police between the appellants and their co-accused when releasing the latter on warning. The effect of releasing some accused on warning, in my view, signaled a significant downscaling of the seriousness of the offense. It then begs the question why, in the absence of a full inquiry, this would only apply to some accused and not all. When applying the principle stated above to the present facts, this appears to have been an instance where the presiding magistrate should have exercised his powers to fully appraise himself of the circumstances which gave rise to some accused being released on warning, whilst the appellants were not. It was open to the magistrate to call any senior police officer who was part of the decision to release some of the accused on warning. That undoubtedly would have allowed the court to fully appraise itself of the reasons explaining the stance taken by the police when releasing only some accused on warning. The differentiation made between the accused for no apparent reason was an important factor to the court to exercise its discretion judiciously. In these circumstances, I am convinced that failure on the part of the magistrate to obtain material information relevant to the outcome of bail proceedings constituted a misdirection. It is settled law that not every misdirection committed leads to the entire proceedings being vitiated, as the effect thereof must be decided against the evidence as a whole. In S versus Shikunga and another, it's a Supreme Court judgment, the court found that, quote, a non-constitutional irregularity committed during a trial does not per se constitute sufficient justification to set aside a conviction on appeal, unquote. That will depend on the nature of the irregularity and the effect thereof on the outcome of the trial, namely whether or not the verdict has been tainted by the irregularity. Next, I turn to consider the court's perception of reoffending and bail conditions. Turning to the risk of further offences being committed by the appellants if they were granted bail, the court a quo reasoned, correctly in my view, that such risk is not limited to the same or similar offences for which the appellants stand charged, but would include any other offence. This is one of the common law grounds for the opposition of bail, and there exists ample authority for the contention that bail may be refused if there is a real likelihood that the accused will commit further offences while on bail. Regard was further had to the fact that the present offences were allegedly committed whilst the appellants were out on bail with conditions, pending the finalization of their respective cases. Also relying on the strength of the state's case, the court found that there was a real likelihood that the state will succeed in proving its case against the appellants. The court then expressed its considered view that the two applicants are alleged to have committed these offences, whilst both of them were out each on bail on other charges with conditions having been attached, unquote, sic. The court further found that there exists a possibility that if released on bail, the appellants may commit further offences. From a reading of the judgment, this was the paramount reason for refusing the appellant's bail. First appellant, during his testimony, stated that he would take no issue with the court imposing any bail conditions if inclined to admit him to bail. This likely prompted the court's remark in the judgment that, quote, given the risk that they may continue to commit further offences, I found no appropriate conditions that would curtail and sufficiently allay the state's fear in this respect, unquote. On appeal, criticism was levelled against the magistrate's approach not to invite either the appellants or their counsel to address the court on possible bail conditions open to the court and which could be imposed if inclined to consider the granting of bail. On appeal, counsel, during oral submissions, submitted on behalf of the appellants that an appropriate condition to bail would be that they may not come within a specific radius of what is generally known as Chinatown. That, it was argued, would allay the state's fear of the appellants reoffending, bearing in mind the purpose of their going into that area in the first place. The court in its ruling did not state which bail conditions were considered and why found to be insufficient, or for what reason or reasons. With regards to the appellants currently being out on bail in cases pending before the High Court, it seems worthwhile mentioning that the first appellant paid bail in the amount of 35,000 Namibia dollars, coupled with conditions which he, according to his own evidence, until now adhered to. The appellants have not yet been convicted on any of the offences they currently stand charged with. Although the magistrate remarked that he, quote, almost, unquote, considered the possibility of admitting the appellants to bail, subject to stringent conditions, this consideration was clearly overshadowed by the risk that they may continue committing further offences. The court's stance on this point was considered by the appellant's counsel to be a violation of the appellant's fundamental rights as they, as far as it concerns their pending cases, have not been convicted and are deemed to be innocent until proven guilty. The respondent's counter-argument is that nowhere in the record does it appear that the court, quote, pronounced itself on the guilt of the appellants and that the appellant's complaint in this regard lacks substance. I agree. Contrary to the view held by the presiding magistrate in the case of S versus Swanepoel, the magistrate in the instant matter went no further than stating that, based on prima facie evidence regarding the strength of the state's case, that, quote, there appears to be a likelihood that the state will succeed in proving its case, unquote. Elsewhere in the judgment, it is clearly stated that it is alleged that the latest offences were committed whilst both the appellants were out on bail. Objectively viewed, I am satisfied that these sentiments expressed by the presiding magistrate fall significantly short of showing that the court, quote, held the view that the appellants were guilty of the offences charged. Submissions contrary thereto are thus without merit. Next, I turn to consider the vexed question whether the court, quote, judiciously and correctly exercised its discretion when refusing bail, primarily based on the risk that the appellants may continue to commit further offences if released on bail. In paragraph 18 of the second appellant's heads of argument, the following are inter alia listed as, quote, undisputed material facts, unquote. 1. The appellant is a social justice activist who carries out his activism not out of selfish or individual needs, but out, seek, the desire to contribute to well-being of Namibians. 2. The pending case and the case in Kazu all emanate from the social justice activities of the appellant. 3. He was simply participating in a protest in order to raise awareness on the issue in the respect where NAMRA burned the goods of Namibians whilst allowing the Chinese nationals to sell the same goods. He did this not for himself, but simply as a social justice activist. During oral argument, counsel for the first appellant said that his client endorses submissions advanced on behalf of the second appellant and further submitted that the testimony of Warrant Officer Nakanyala was entirely based on hearsay evidence relating to statements and video material in possession of the police. The latter issue is discussed below. The picture portrayed by the appellants about them being social justice activists who, on the day of their arrest, were merely participating in a protest in order to promote awareness of the government's actions when destroying seized contraband, stands in sharp contrast with the evidence of the investigating officer testifying for the state. His evidence was summarized in the court's ruling and amounts to the following. Based on the video recordings, the first appellant could be seen telling the Chinese nationals that if they do not close their shops will be set ablaze, and that he, that is first appellant, will tell members of the public to loot the shops. He further uttered words to the effect that the Chinese nationals will burn with their shops. As for the second appellant, his arrest came as a result of disregarding a police order to disperse, and that he encouraged members of the public to do the same. Coming to the testimony of the first appellant, this court will undoubtedly fail in its duty if nothing is said about the attitude of the appellant displayed during cross-examination by the state. The appellant's demeanor smacked of arrogance, and his answers to questions relevant to the inquiry too often were sarcastic and clearly intended to insult the person of the prosecutor. At some point, the court appropriately issued a warning to the appellant and advised him to rather focus on the questions posed and which he was required to answer. Such behavior by a witness when giving evidence is unnecessary, unacceptable, and must be discouraged in the strongest terms. Not only does it erode the decorum of the court, it is simply not in the interest of justice to allow such behavior in a court of law. It should therefore be nipped in the bud by presiding officers the moment it raises its ugly head. When put to the first appellant in cross-examination that the state is in possession of evidence to the effect that the threatened Chinese nationals that he will set them and their shops ablaze if they don't close down their shops, the appellant initially chose not to comment, but when pressed for an answer, replied that he went there to protest. He persisted with the same answer that they went there to protest, which included the closing of shops. First appellant further conceded that he had no permission to convene a public gathering. Without divulging into the merits of the case in any detail, it is evident from the appellant's own evidence that their respective involvement in the so-called protest exceeded their initial claims of having simply participated in a protest as social justice activists. They clearly did not take the court fully into their confidence when presenting their case in the bail application. The reason for doing so could only have been to diminish the seriousness of their actions. It is against this background that the respondent argued that both appellants have displayed conduct which shows complete disregard for the law, conduct that is not in the interest of society. Despite the serious nature of the charges preferred against the appellants, moreover, where their actions were directed at certain members of the public, the extent of these actions must be viewed in context. Although their aim was to close down shops belonging to Chinese nationals with the accompanying threats of setting them, the owners and their shops, ablaze, and which likely would have engaged those taking part in the protest, nothing came of it except for having themselves arrested. Nobody was physically harmed, neither was any damages done to property. In view of both appellants' self-proclaimed status of being social justice activists, there justifiably appears to be reason for concern as to their possible future behavior when pursuing their cause. The magistrate clearly entertained these thoughts when finding that there exists a possibility that the appellants might commit further offences when released on bail. Furthermore, mindful of the appellants already being out on bail in pending cases, the risk of reoffending, as mentioned, was paramount in the court acquo's conclusion when refusing the appellant's bail. When deciding the risk of further offences being committed, bail may be refused if there is a real likelihood that the accused, appellants in this instance, will commit further offences while out on bail. Despite the concerns raised earlier about the appellant's possible future conduct in pursuing their cause, no evidence was placed before the court acquo showing that, objectively viewed, there exists a real likelihood of it happening. Neither does the fact that both appellants have pending cases against them for which they are on bail per se establish such likelihood. The court in Jacobus Adrian Pinar versus the State at paragraph 16 endorsed the remarks made by Silly, J.P., in S versus Patel at page 568, paragraphs A to B, which reads, and I quote, "It seems to me that an applicant's past record, his actions immediately prior to the application for bail, and particularly while he was out on bail in respect of another charge, may be relevant factors, particularly when they indicate a propensity to commit a particular type of crime," unquote. As stated, both appellants were out on bail when arrested and charged in the present matter, while first appellant has a previous conviction of culpable homicide. The previous conviction of culpable homicide stems from a motor vehicle accident. Though these factors are usually considered to be of relevance in bail application, it falls short of showing a propensity on the part of the appellants to commit crime. The offences charged in the cases in which they were out on bail are completely different from the ones they are currently facing and for which they are deemed innocent until proven guilty. It is my considered view that the protest where the appellant's arrest was the direct consequence of their actions on the day was an isolated incident aimed at specific business owners and not the public at large. Not to say that the rights of these persons are inferior to that of others. The fact remains that the appellant's conduct was limited to a specific incident, which was brought under control with the arrest of the appellants and their co-accused. In these circumstances, one should guard against placing too much weight on what harm could have come from the appellant's actions, instead of focusing on established facts. Reference was earlier made to the 6 co-accused who were released on warning, despite facing the same charges as the appellants. There is nothing in the record that remotely explains or justifies the inconsistent handling by the police of the appellant's case, opposed to that of their co-accused. The mere fact that the co-accused were released on police warning, as said, rather suggests that the offences charged were regarded to be of less serious nature. For some reason, this did not apply to the appellants. While the true reasons were not explored, the only reasonable conclusion to reach is that the disparity was because both appellants were already out on bail on other cases. In my considered view, all the above mentioned are relevant factors which the court acquo should have taken into consideration when deciding the application for bail. Failing to do so constituted a misdirection to the extent that it warrants interference by this court. The next ground is the strength of the state's case and the admissibility of hearsay evidence. The court acquo admitted the evidence of the investigating officer, Warrant Officer Nakanyala, and on the strength of that evidence was satisfied that the state has a strong case against the appellants. It went on to say that based on that evidence, there is prima facie proof that the appellants are implicated in the offences for which they are charged, while a real likelihood existed that the state will succeed in proving its case. Regard was further had to the appellants being out on bail, which, in the court's view, strengthened the possibility of the appellants committing further offences. It was contended on the appellant's behalf that the court's reliance on the strength of the state's case is misplaced, in that it had not been found that the appellants are a flight risk. Furthermore, that the court committed a misdirection when relying on inadmissible hearsay evidence in coming to the conclusion as it did. As authority for this contention, counsel relied on the case of Unengu versus the state, where the court at page 5, paragraph 4 held as follows, and I quote, Most of the evidence adduced during the bail hearing was about A and B, i.e., the seriousness of the charge and the strength of the state case. It is tried law that the primary reason for these factors is to establish an inducement to abscond and not stand trial. And then follows a number of cases cited in the quote, which I'm not going to read. In other words, in assessing the risk of flight, the courts may properly take into account not only the strength of the case of the state and the probability of a conviction, but also the seriousness of the offence charged and the concomitant likelihood of a severe sentence. In this case, the risk of abscondment was not an issue, but the magistrate seems to have used these factors to conclude that it was not in the best interest of the public or the administration of justice that he be released, unquote. I respectfully endorse these sentiments. In the same vein, this court, in Micheal and others versus the state, cautioned that factors, quote, factors such as to whether or not it would be in the interest of justice to grant the appellant's bail, or whether the state has a strong or weak case against the appellants, must not be viewed in isolation. As with the evaluation of all evidence, the court must follow a holistic approach when assessing and weighing the evidence for and against the applicants in a bail application, unquote. When applying the above stated principles to the present facts, it is not clear from the judgment how the court's finding that the state has a strong case against the appellants and likely to prove the charges against them assisted the court in reaching its final conclusion. Besides mentioning in passing that the offence of public violence falls under Part 4 of Schedule 2 of the CPA, the court latched its earlier finding of a possible conviction to the fact that both appellants were out on bail at the time. This, in turn, fortified the court's finding that there is a possibility of the appellants committing further offences. Although the court acquo's reference and reliance on the strength of the state's case may be out of sync, in the absence of evidence that the appellants being considered a flight risk, it is evident from the court's inferential reasoning that this was a factor relied on when considering the possibility of the appellants committing further offences. It should, in my view, not be assessed in isolation, but as a factor weighed and considered with the rest of the evidence. See Micheal supra. I therefore do not agree that the court acquo misdirected itself in this regard. Next, I turn to the issue of admissibility of hearsay evidence, i.e. the investigating officer's testimony about witness statements and video recordings in possession of the state. During oral submissions, Mr. Amumu submitted that as a result of contradicting judgments delivered in this jurisdiction on hearsay evidence, guidance is sought from this court to clear up the uncertainty that exists among legal practitioners. In particular, he referenced the Botha case, Supra, and Jackson Barbie versus the state. I pointed out to counsel that he seems to have misread the judgments and seems to not understand the difference between the admissibility of evidence and the weight to be accorded thereto, once admitted. Neither of the cited cases exclude hearsay evidence as admissible in bail applications. In Barbie, the following appears at paragraph 13, and I quote, "Pertinent to bail applications is that the state, through the investigating officer, places before court the evidence it has at its disposal. This does not per se mean that the state is required to produce the actual evidence it intends presenting all the witnesses in the matter, but simply to indicate what evidence it has at its disposal. The state may, however, be required to present such evidence for the court's perusal, if so requested by the court, but there is no rule in bail applications that it must be handed up as an exhibit before the trial commences. Therefore, the assertion that evidence can only be introduced by way of attachment of cell phone records, a photo plan, and a forensic report to the answering affidavit does not apply to bail applications. The production of these documents are at the discretion of the state at the bail application. Where the state does not produce these reports, this does not mean that the averments by the investigating officer cannot safely be relied upon. There can be various reasons why the state may opt to not produce exhibits as part of their evidence during bail applications. This can be because investigations are still at an early stage, or that further investigations are to be done on certain aspects contained in the said exhibits. It is therefore not practice that forensic reports and cell phone records necessarily need to form part of the bail record in support of the investigating officer's evidence, unquote. The court in the Botha case stated the following at page 8 on hearsay evidence in bail applications, and I quote, "Although hearsay can be admitted in bail applications, such hearsay can carry little weight, if any, and should not be relied on when disputed," unquote. In the present instance, the appellants bluntly denied the charges against them, and when afforded the opportunity to respond to the testimony of the investigating officer, the extent of their testimonies amounted to nothing more than them staging a protest. The hearsay evidence adduced by Warrant Officer Nakanyala was accordingly left unchallenged. The present facts differ significantly from that in the Botha matter as regards hearsay evidence, and I do not agree with the contention by counsel that the court, I quote, misdirected itself either by admitting hearsay evidence or giving weight thereto as borne out in the judgment. The next ground of appeal is the court's reliance on Section 61 of the Criminal Procedure Act 51 of 1977. As already alluded to, the court merely mentioned in passing that the offence of public violence falls under Part 4 of Schedule 2, whereas the court did not otherwise pronounce itself on whether the provisions of Section 61 of the CPA were actually invoked. It does not appear to be the case. That probably came about due to its finding that there exists a risk that the appellants may reoffend, thus relying on one of the common law grounds. Having come to this conclusion, the grievances raised by the appellants in this regard require no further consideration. The next ground is the absence of evidence concerning the risk of possible harm or danger to the public caused by the appellants. This ground of appeal has to a large extent already been discussed under the risk of the appellants committing further offences, and equally overlaps with what has been said as regards the court's non-reliance on the provisions of Section 61 of the CPA. Suffice it to say that the possible causing of harm to the public is an important factor when it comes to the decision whether or not to grant the appellant's bail. To this end, the court in the Botha case outlined that public interest considerations arise in instances when an accused person is alleged to be dangerous, or having committed brutal or callous murders, or robbery using dangerous weapons, or rape where serious injuries were inflicted, or where a small child had been raped, or where the accused is a habitual criminal, or where he has a personality of being violent, dangerous, and uncontrollable, without warning and at slight provocation, and where an accused person's release creates a legitimate fear in the victim's minds, even if there is no proof that that would occur. It may also be created in the minds of the public that the courts are unable and unwilling to protect them. The public needs to be protected and not to be exposed to such dangers and risks. These perceptions should be avoided by considering all factors in bail proceedings, provided that the relevant facts are placed before the judicial officer. Conclusion. In S versus Pinheiro, the principles applicable to bail were stated in the following words at page 580, paragraphs B to D, and I quote, "The overriding principles guiding an application of this kind are succinctly set out in de Toey et al. In commentary on the Criminal Procedure Act and in his notes to section 60 thereof at 9-8b, the following is stated, and I quote, "In the exercise of its discretion to grant or refuse bail, the court does in principle address only one all-embracing issue. Will the interest of justice be prejudiced if the accused is granted bail? And in this context, it must be borne in mind that if an accused is refused bail in circumstances where he will stand his trial, the interests of justice are also prejudiced. 4 subsidiary questions arise. If released on bail, will the accused stand his trial? Will he interfere with state witnesses or the police investigation? Will he commit further crimes? Will his release be prejudicial to the maintenance of law and order and the security of the state? At the same time, the court should determine whether any objection to release on bail cannot suitably be met by appropriate conditions pertaining to release on bail. See generally S versus Bennett," unquote. When applying these principles to the present facts, I am satisfied that the question as to the appellant's absconding or interfering with the state witnesses or police investigation did not arise in the bail application. As to the question whether the appellants will commit further offences, I am satisfied that the evidence adduced did not establish that a real likelihood exists that the appellants will reoffend when out on bail. In deciding whether their release would be prejudicial to the maintenance of law and order, and in particular towards certain members of society, I am convinced that any future conduct by the appellants being prejudicial to the maintenance of law and order or public interest could be countered by appropriate bail conditions. It is my considered view that the interest of the administration of justice does not require the continued detention of the appellants pending the finalization of their case. The Court Akwo's decision when refusing bail in this matter is accordingly found to be wrong and falls to be set aside. Lastly, in view of the charges preferred against the appellants and their proclaimed status as activists who are ready to mobilize and or partake in unlawful public protests, it seems necessary to remind the appellants that in a democratic society, all persons are equal before the law, whilst the rights of all persons are guaranteed and protected under the Namibian Constitution. In a democratic state as ours, the executive authorities oversee and uphold the rule of law, and it is not for individuals to take the law into their own hands. Such conduct is likely to promote lawlessness and must be condemned in the strongest of terms. In the result, it is ordered. 1. The appellant's appeal against the refusal of bail in the Court Akwo is upheld. 2. Bail is granted in respect of each appellant in the amount of 5,000 Namibia dollars on the following conditions. 1. The appellants shall not mobilize or involve themselves in any unlawful public gathering. 2. The appellants are prohibited to enter a radius of 1 kilometer of the area known as Chinatown, situated in the district of Windhoek. I hand down the judgment. That concludes the appeal roll. The court is adjourned.
You are